All right, hello everybody. My name is Marcus Steade. I'm going to be giving a presentation on the philosophical concept of security versus privacy in the technological age. Now, what brought this subject on was Apple's current troubles with the FBI, as the FBI is trying to get Apple to unlock their iPhone. Earlier this year, the technology company Apple was served with a court order requiring it to develop code that would weaken its security function of some of the versions of iPhones. This is an attempt by the FBI and the Justice Department to obtain access to the phone of Steade, a suspected terrorist who, with his wife, entered the workplace and killed several coworkers. On the surface, it seems like a simple case. The FBI claims they're only asking for access to this one phone. But just so happens that federal prosecutors in Manhattan said they have over 170 iPhones they would like to access from crimes ranging from drug dealing to murders. Apple is appealing this court order, citing several arguments. The first is that the government cannot conscript it into doing its bidding. The second is that such a code could not remain secure and would eventually make its way into the hands of the criminal organizations and oppressive governments. The third is if the FBI had such a tool, it would lead to violations of privacy rights. If the courts require Apple to create such a code, it would be setting a precedent that would allow it to do so to other companies and take similar actions. Apple's head of services, Eddie Q, states that if the government prevails, it could require Apple to turn on microphones and cameras of iPhones without the users being aware of it and allowing the government agents to spy on the citizens. This opens a larger discussion of the government's need to provide security for its citizens versus those citizens' rights to privacy. And this is compounded by the fact that technological capabilities that are available. We want to talk about what rights we have to privacy versus the government's need to provide us security. We want to go over a little bit about what is the technology, what does the security mean to us, and what kind of privacy we're going to be expecting. What level of privacy we want. So what is technology and how does it affect us? Technology is defined as the use of scientific knowledge for practical purposes, especially in industry. Today we have come to rely on computer technology. There has been so much technological innovation with computers over the past 20 years that technology has permeated nearly every aspect of our daily lives. The same technologies we develop to make our lives simpler and more productive can also be used to harm us. This harm can come in many forms, including physical, social, financial, and legal. It can be used to secretly observe us in our homes, our cars, walking down the street, shopping in the stores, using restrooms, or talking to our friends. It can be used to expose damaging photographs or thoughts and opinions we wanted no one else to see. But we require security for these technologies. So, what are the types of technologies that most affect us? Predominantly, it's computers. As we discussed earlier, computers are prevalent throughout our modern lives. Some of us have one or more in our homes. According to the Pew Research Center, a study done in 2014, 84% of adult Americans own a computer, with 73% of those having broadband internet connections. We use them to store pictures, videos, contacts, financial data, personal musings, watch online videos, play games, and communicate with others nearly anywhere around the world by text, voice, or video messaging. We do banking, file our taxes, research subjects, and participate in social and political group conversations. I could go on for some time if I tried to list every activity we use computers for, but for now let's just say we rely on them. The next technology we're going to talk about is smartphones. Smartphones are computers. They're small, they're portable, they're with us everywhere we go. 64% of adult Americans own smartphones. They do just about every function a home computer does, plus it's a phone. Younger people are more apt to have a smartphone with them everywhere they go, and they're more apt to have a greater level of personal data on the smartphones. Everywhere you go, you see people with their phones out, heads down, performing some function, searching the internet, texting friends. This reliance makes it a bigger risk. The next category we have will be smart appliances and home security systems. Now, these are computer-like devices we possess, but they aren't nearly as prevalent as the first two mentioned. So I'll group them all together as smart appliances and home security systems. They include wearable devices used to track our health, our physical activities, as well as our geographical location. We have smart cars, kitchen appliances, controllers for our heating and air devices, door locks, and home security systems. These devices connect directly to the internet or to another internet-capable device. They are designed to offer us a more efficient and convenient and safer lifestyle. Unfortunately, they can be accessed and misused by those who would wish us harm or to invade our privacy. And we also have technologies that are specific to government agencies and law enforcement. Now, of course, they have computer systems, offices with workstations connected to servers. Some organizations have data centers that hold vast amounts of data on citizenry, foreign government activities, and criminal activities. They have tracking devices, listening devices, video monitoring and recording devices used to spy on whomever they care to spy on. They have reconnaissance satellites, drones, and of course you have the NSA, which is a large data collecting organization. It's estimated that there's over 1,000 satellites operational and circling the globe every day. Not all satellites are used for reconnaissance by the government, but the ones that are and their capabilities are kept classified. But we do know that they have them in some degree of ability for photographic and communication surveillance. Drones. The U.S. military has been using drones in combat zones for years. They have been used to gather intelligence of enemy movements and deliver ordnance payloads to the enemy. Drones have increasingly been used domestically for surveillance, first with border control and now with state and local law enforcement wanting to use them. So much so that states have enacted legislation restricting unwarranted drone use. The NSA, or the National Security Agency, is an intelligence organization of the United States government responsible for global monitoring, collection, and processing of information and data for foreign intelligence and counterintelligence purposes. And as we've all been made aware of by the Edward Snowden leaks, the NSA has long been collecting any data sent electronically en masse and indiscriminately for years. This data is not only on foreign enemies, but allies and U.S. citizens alike. Some of this metadata was even collected from foreign locations in order to bypass U.S. restrictions. Well, that brings us to the topic of security. Now, with all this going on, we want security. So what do we mean by being secure in today's age? What are we trying to be secure from? For most of us, we think of it as the ability to live our lives without being harmed or harassed. We imagine foreign terrorists, suicide bombers, even domestic groups intent on killing and maiming us in some way, trying to destroy our way of life. For others, it may mean being able to go about their lives without individuals and governments watching and listening to everything we do. Collecting data on our lives and the possibility of the data being used against us in some way. either in a criminal case, extortion, or an attempt to embarrass us. Security is the desire to be protected from harm, and for that we rely in part on the government. We task the government with the responsibility of ensuring our security. It's a daunting task with many obstacles. Groups can be organized where planners and financial backers are insulated from the persons carrying out the actions. Legal restrictions can prevent law enforcement from easily gathering the evidence that will allow them to take action before an event occurs, or to not only get the people carrying out the act, but those who plan and finance it as well. Then, of course, you have the technologies that make it difficult to track and surveil and gather the evidence against these people. We developed these technologies to try to secure our privacy. So what are we talking about when we talk about privacy? Well, privacy is the state or condition of being free from being observed or disturbed by other people. In today's society, that condition is nearly impossible to achieve. It's estimated that there's 319 million people in the United States with a landmass of 3,806,000,000 square miles. And that's about 12 people per mile. And that's if we're all spread out evenly, but most of us live in cities and suburbs where the population is denser. We also have computers and electronic devices that connect us to people from all around the world. So with this in mind, everyone who connects to the internet is observed in one way or another. Companies track our web browsing, have access to our geographical location, track our purchases, and most of us freely divulge much of what we do on social media. And of course, that information is collected and used by those sites for the purpose of trying to sell something. So the question arises as to why we think we have any privacy at all. The digital data that we create in our lives is somehow collected by people, companies, and governments with the intent on using it to either to better tailor products for us or an attempt to monitor for illegal activities. In this case, the privacy we're talking about is unwelcome access to our data about others and intrusive and warrantless government observations. So, is there a right to privacy? In the United States, there is nothing specific that says you have the right to privacy. Not expressly, but there is the Bill of Rights that reflects the concerns of the framers of the Constitution has had on protecting certain aspects of privacy. So, what are the constitutional rights for protecting privacy? The privacy of beliefs protected in the First Amendment, the privacy of home against demands it be used to house soldiers in the Third Amendment, the privacy of the persons in possession as against unreasonable searches, the Fourth Amendment requiring the government to show probable cause to obtain search warrants, and the Fifth Amendment privilege against self-incrimination, which provides protection for privacy of personal information. Some have interpreted the Ninth Amendment to mean that the Bill of Rights protects privacy in ways not listed in the first 8 amendments. Now, is there an expectation of privacy? When we divulge so much of our personal information so freely on websites and willingly allow corporations to collect so much information about us, how can we say that we have an expectation of privacy? Well, the answer is this. It is up to us to determine who our information is shared with and how it is used. You can always opt out. And how does security protect privacy? How does security affect privacy? Today, many corporations offer the use of cloud services. Well, unfortunately, those cloud services are not protected. And in the first half of 2015, Apple allowed U.S. law enforcement access to the data of 1,886 individuals. These companies have your information and they are able to use it. Excuse me. The government, in its quest to obtain information of evidence of illegal activity, has tried to use our own devices to monitor our actions. Law enforcement was once requiring unwarranted access to cellular phones of people they detained in order to get potential evidence until the Supreme Court ruled that it is a violation of Fourth Amendment rights. Recently, law enforcement stated that it will start using the information gathered from wearable fitness devices to determine the geographical location of a suspect and the activity level that person may have been up to. The Department of Homeland Security was once offering grants to municipalities to operate drones for surveillance purposes. In Florida v. Riley, the United States Supreme Court held that individuals do not have the right to privacy from police observation from public airspace. This led some states to enact legislation requiring warrants for drone surveillance except in limited circumstances. The NSA gathers unimaginable amounts of data on us, tracks our cell phones, and monitors our computer activities, all without the use of warrants, as evidenced by the Edward Snowden leaks. Project Hemisphere began in 2007 and was not made public until 2013 as a mass surveillance operation carried out by the communications company AT&T and the DEA, where the DEA makes use of administrative subpoenas instead of search warrants on all calls that use AT&T switches, not just calls by AT&T customers. So how much privacy are we willing to give up for security? Well, that is the million-dollar question. In times of war, we're willing to give up a portion of our civil liberties. It's war. The enemy's always trying to infiltrate our society so that they too can gather intelligence. When the war is over, those liberties are restored. After September 11, 2001 terror attacks, several of the restrictions placed on the government by the Constitution were relaxed. Secret courts were established and the threshold for domestic surveillance was lessened. Would more lenient surveillance rules stop the perpetrators? Some of the 11 hijackers were already on watch lists as known Al-Qaeda affiliates. And they were also brought to the attention of FBI field agents for suspicious activities. The Russian government warned U.S. authorities that the Boston Marathon bomber Tamerlan Tsarnaev was a violent radical Islamist more than a year and a half before the April 2013 bombing. But authorities missed multiple chances to detain Tsarnaev when he was traveling to and from Dagestan for terror training. He was on a watch list but slipped through the airport security because someone misspelled his name in a security database. Now, as for the San Bernardino attacks, was there anything that should have led law enforcement to consider these people a terrorist threat? It appears they took great care not to draw attention to themselves, getting a neighbor to purchase the weapons they used in the attacks. It doesn't appear that casting a wide and inclusive surveillance net would have helped prevent the attacks as much as more competently using the information that was already available. Now, should the government of a free society be able to monitor the actions of the citizens without limitations? We've already established that the U.S. has rights embedded in the Constitution that limits the ability of the government and law enforcement to spy on its citizens. But these rights are constantly being challenged. Arguments are made that due to the fact that the authors of these rights could not have imagined the technological world that we live in today and the threats to our way of life, and therefore the interpretation of these rights need to be done from a modern perspective. But can a society be free if it cannot be free from government intrusions? Now, has the government or law enforcement ever violated the privacy and constitutional rights of its citizens? Yes, they have, and they have done so at the institutional level. These organizations are made up of people who want to accomplish their goals, whatever they may be. To some, the ends justify the means. There are many examples of government overreach and rights violation and downright criminal abuses of citizens' rights. A few of these examples are the provisions of the Patriot Act, COINTELPRO, Watergate, and a program for warrantless surveillance by NSA, and eugenics. The Patriot Act. After the terror attacks of September 11, 2001, Congress passed laws that would allow law enforcement to easily access information in order to go after terrorists. When the Patriot Act was enacted, there was a compromise between those who wanted to leave U.S. intelligence agencies free from restrictions and those who wanted intelligence agencies to apply for search warrants like other law enforcement agencies. Congress required U.S. intelligence agencies, the FBI and the National Security Agency, to apply for warrants for wiretaps and other surveillances on foreign governments and suspected foreign agents. But because the agents are not investigating domestic crime, they do not have to meet the probable cause standard. They only have to certify that the purpose of the investigation is to track foreign government or agent. They do not have to report to the courts on the results of the surveillance. The court meets in secret with only the government representative present and has never denied intelligence agency's application for a search warrant. The Patriot Act expands all the exceptions to the probable cause requirement. Section 215 of the Act permits the FBI to go before the Foreign Intelligence Surveillance Court for an order to search for any tangible things connected to a terrorism suspect. The order would be granted as long as the FBI certifies that the search is to protect against international terrorism and clandestine intelligence activities. But the FBI would not need to meet the stronger standard of probable cause. The Patriot Act now authorizes a court to issue search warrants directed at any U.S. citizen who the FBI believes may be involved in terrorist attacks. Such activities may in part even involve First Amendment protected acts, such as participating in nonviolent public protests. In Section 215, any tangible things may include almost any kind of property, such as books, documents, and computers. The FBI may also monitor or seize personal records held in public libraries, bookstores, medical offices, internet providers, churches, political groups, universities, and other businesses and institutions. The Patriot Act prohibits third parties served with Section 215 orders, such as internet providers and public librarians, to inform anyone that the FBI has conducted a search of their records. Section 216 of the Patriot Act extends pin trap orders to include email and web browsing. The FBI can ask internet service providers to turn over logs of the websites a person visits and the addresses of emails coming to and from a person's computer. Another area of concern is Section 213 of the Patriot Act. It authorizes so-called sneak and peek searches for all federal and criminal investigations. When applying for a search warrant, officers may show that there is a reasonable cause to believe that providing immediate notification may have an adverse result. If the judge approves, the FBI can delay notifying a citizen about the search for a reasonable period. Thus, the FBI may search a citizen's home or business in secret. The FBI says these searches may be necessary to prevent destruction of evidence or to keep from jeopardizing an ongoing secret investigation. The next program they did was COINTELPRO, which is derived from Counterintelligence Program. It was a series of covert and at times illegal projects conducted by the United States Federal Bureau of Investigation aimed at surveilling, infiltrating, and discrediting and disrupting domestic political organizations. FBI records show that COINTELPRO resources targeted groups and individuals that FBI deemed subversive, including anti-Vietnam War organizers, activists of civil rights movement, feminist organizations, and a variety of organizations that were part of a broader New Left. And Watergate. Watergate was a major political scandal that occurred in the United States in the 1970s, following a break-in at the Democratic National Committee, headquarters at the Watergate office complex in Washington, D.C., in order to photograph campaign documents and install listening devices in telephones, and President Richard Nixon's administration's attempt to cover up its involvement. When the conspiracy was discovered and investigated by Congress, President Nixon tried to exercise executive privilege, and the administration's resistance to this probe led to a constitutional crisis. The scandal led to the discovery of multiple abuses of power by the Nixon administration, articles of impeachment, and resignation of Richard Nixon as President of the United States in 1974. The scandal also resulted in the indictment of 69 people with trials or pleas, resulting in 25 being found guilty and incarcerated, many of whom were Nixon's top administrative officials. The NSA warrantless surveillance controversy. The NSA warrantless surveillance controversy, or warrantless wiretapping, concerns surveillance of persons within the United States during the collection of allegedly foreign intelligence by the U.S. National Security Agency as part of the touted War on Terror. Under this program, referred to by the Bush administration as the Terrorist Surveillance Program, part of the President's broader surveillance program, the NSA was authorized by executive order to monitor, without search warrants, the phone calls, internet activities, web, email, etc., text messaging, and other communications involving any party believed to be by the NSA to be outside the U.S., even if the party on the other end lies within the U.S. However, it has been discovered that all the U.S. communications have been digitally cloned by the government agency in an apparent violation of unreasonable search and seizure. The next program started in 1907 and continued on to 1937. It was not a federal program, but it was administered by 32 states. It's called eugenics. Eugenics is a set of beliefs and practices that aims at improving genetic quality of the human population. It is a social philosophy advocating the improvement of human genetic traits through the promotion of higher rates of sexual reproduction for people with desired traits, which they call positive eugenics, or reduced rates of sexual reproduction and sterilization of people with lesser desired or undesirable traits, called negative eugenics. Eugenics was practiced in the United States many years before the eugenics program in Nazi Germany, and the U.S. programs provided much of the inspiration for the latter. Indiana became the first state to enact sterilization legislation in 1907, followed closely by Washington and California in 1909. Sterilization rates across the country were relatively low until 1927, when the Supreme Court ruled in Buck versus Bell that the states had a legal right to force sterilization of patients at a home in Virginia for the mentally retarded. The number of sterilizations performed per year increased until another Supreme Court case, Skinner versus Oklahoma in 1942, complicated the legal situation by ruling against sterilization of criminals if the Equal Protection Clause of the Constitution was violated. That is, if sterilization was to be performed, then it could not exempt white-collar criminals. The North Carolina eugenics program, which operated from 1933 to 1977, was the most aggressive of the 32 states that had eugenics program. An IQ of 70 or lower meant sterilization was appropriate in North Carolina. The North Carolina Eugenics Board always approved proposals brought before them by local welfare boards, Of all states, only North Carolina gave social workers the power to designate people for sterilization. Some of the criteria for sterilization included mentally ill, the blind, the deaf, the developmentally disabled, promiscuous women, homosexuals, and those they deemed feeble-minded. Now, as the case for Apple versus the FBI moves further along in the courts, remember that this is just a small portion of the larger discussion of privacy rights versus security. Should companies be required by the government to create vulnerabilities in their products and allow access to personal information or be used to spy on citizens? How will these backdoors be used and what other restrictions will be applied? Will it be those required by the Constitutional Bill of Rights or the lesser restrictions by the Patriot Act? Think of the proliferation of technology products in every aspect of our modern lives, what information they hold and what their capabilities are. Consider that what, as a technology professional, you may be asked by the government to do. Will it align with your values? Think of what Edward Snowden has had to sacrifice when he brought to light the constitutional violations by NSA. Apple's attorneys talk about, in their argument, what precedent this ruling will set, not just for Apple, but for other tech companies. Think about the precedents already set by the government. Unwarranted mass collection of digital communications by NSA of U.S. citizens, illegal wiretapping and infiltrations and attempts to discredit nonviolent civil organizations, the criminal activities and abuses of power by the sitting U.S. president and his minions, and finally about how his social philosophy was used to develop laws that restricted the right of certain people to marry, to force sterilize people deemed to be unfit to reproduce, and how these laws were upheld by the Supreme Court. Thank you.